Welcome to the Wills and Estate Transmission Podcast, brought to you by De Groots, specialist lawyers in wills and estates.
So, Marie, when we look at the court, it's a big body. We probably regard it as an unfriendly body, but this is the family court. Is that right?
No, we're looking at the Supreme Court of New South Wales, Tony. So that's where all the claims are lodged in New South Wales. Really, the way you commence proceedings is you file a document called a summons, and that basically is a document that you file within the court together with your affidavit, which is like your statement, and a costs affidavit and a notice of eligible persons, and then that is what commences proceedings in New South Wales.
Right, so how do the matters work within the court?
So once you lodge your summons in court, you're likely to get a date for a directions hearing, and that's normally within 28 days of you lodging your summons. Once you get a directions hearing, you would turn up, or your lawyer would turn up, and really the judge would just set a timetable for the matter. Mediation is compulsory in this area of law, Tony, so the judge will send you off to a mediation and you'll try and resolve the matter there. And really 90 to 95% of my matters tend to settle at a mediation. It's only a very small percentage that go off to a court hearing. Because going to court, it's a slow process. The courts are so full with all the different matters that they're hearing. You're unlikely to get a hearing date until, say, a year from the date you commence court proceedings. So it's quite a long time to wait. And if you can try and resolve the matter by going to a mediation, it's really better for everybody. I often say to my clients, the only people that really benefit from going to court are the lawyers, because they charge more fees by going to court, whereas if you can try and resolve it at mediation, you get certainty, you can put the matter behind you, and you don't have the stress of going to a court hearing, which people often don't want to experience. It's not a fun thing unless you're the barrister cross-examining the other client or the other party at the hearing.
Because that is what happens. So the barristers do pop up. So I didn't think of that, because I only thought that was only in criminal.
No, so barristers are involved in this area. So if you are contesting a will, you'll have your solicitor, and then also on your team you'll have a barrister who would basically be your advocate and who would run the matter if it did go to a court hearing. And similarly, the other party on the other side, who will be, say, the defendant in this scenario, they would have a lawyer and a barrister. So the barrister would come with you to the mediation, and again, if it didn't settle at mediation, they'll come with you to a hearing.
Okay. So there is a large case going on in Western Australia at the moment, mining royalties and the like, and I believe there's 10, 20 lawyers involved. So I guess when it comes to large sums of money, it might be worth it.
Yes, as I said, it depends on the case. So, there's obviously, if there's a large estate, there's a bigger share of the pie that's available to be divided amongst people. So people want to try and have a go and try and contest the will and get a share of the pie. And as I said, if they've been left out of the will, that might be the only way that they can try and get a share of the pie. But it really depends on each case, because the applicant is very well off, then that's not going to go well for them if they did try and contest the will.
So what are the chances of winning?
That's a good question. Again, it depends on the case. And I know that I keep saying that to you, Tony, but there's certain considerations that the court will look at. They'll have a look at your relationship with the deceased. They'll also look at the obligations that the deceased owed to you. They'll look at the size of the estate. They'll look at your financial resources and your financial needs. They will look at whether or not you're living with another person and the financial circumstances of that other person. They'll look at your health circumstances and whether you suffer from any physical, intellectual or mental disability. They'll look at your age at the time that the application is being considered. They'll look at any contribution that you've made to the welfare or to the estate of the deceased person. They'll look at any provision that's been made for you, whether you're a beneficiary of any prior wills or the testamentary intentions of the deceased, whether or not you were being maintained by the deceased at the time of death, whether any other person is liable to support you. So there's a range of matters which the court is going to look at, and they're set out in Section 60 of the Succession Act. So ultimately, it's not any particular one factor that the court's going to look at, but it's going to look at potentially all those factors that I mentioned. So if you are, for instance, very well off and you own your own properties and you've done quite well for yourself and you're earning a very high income, and it's a very small estate, and you've been, say, estranged from the deceased for a significant period of time, you're going to have an uphill battle to try and contest the will. But if you've been a dutiful child, for instance, and you're on hard times and you're struggling at the moment, and you've had a fairly decent relationship with the deceased, then your chances might be a little bit better.
Wow, okay. And you went through a whole list of things that gets considered, and I guess that gets argued each time.
Correct, yes. So as I said, they're just a list of the things that the court may look at, but that's what you're really basing your client's case upon. So you're looking at each of those factors and you're setting out all that information in your client's affidavit, which is, as I said, their statement, and you're trying to argue that they haven't been adequately provided for in the deceased will, and further provision should be made for them, or provision should be made for them.
Yeah, and you've touched on the right word then,
yes.
The will. So having a well-drafted will with a good solicitor makes a difference.
It certainly does, Tony. And as I said, here at De Groots, we've got an estate planning team, and our team goes through all these types of considerations with clients when we're taking instructions to prepare wills, because, yes, we've seen what happens if you don't have a properly prepared will, and you really don't want to end up in litigation, because it's just going to eat out a size of your estate, and there'll be a chunk that's gone from your estate which would basically go to lawyers, and that's money that could be divided amongst your beneficiaries or your family.
Okay, so Marie, we've got a question. I know what you're going to say initially, but we'll ask it anyway. How much does it cost to contest a will?
Well, Tony, it really depends, because there's court fees and there's also solicitor's fees. So when you contest a will and you lodge your summons in the Supreme Court of New South Wales, you pay a court filing fee. In addition to that, when your matter is set down for hearing, you pay a hearing allocation fee. So there are disbursements like that. Then you've also got your barrister's fee. Now, again, your barrister's fee is going to depend on which barrister you brief. So if you're briefing a junior counsel or a senior junior or a silk, which is a senior counsel, if you're briefing a junior counsel, they're going to be cheaper than a senior counsel. It also depends on, for instance, how long the matter goes for. So if it's set down for a one-day mediation, or if it's set down for longer than that. If it's set down for a one-day hearing, that's going to be cheaper than if it's set down for a 5-day hearing. And then again, it depends on which lawyer you use. So some solicitors are cheaper than other solicitors. Again, it depends on how much work your solicitor has to undertake on your matter as well. So ultimately, it will depend on those various factors that I've just listed.
Yeah, well, I was just thinking about the name of probably one of the biggest cases, and that's the Hancocks. And it's still going through now after all these years. And he had his legitimate children, illegitimate children, all sorts of mega claims. And that's what happens when there's lots of money and I guess some poorly written wills.
That's right. So again, it'll depend on, can you resolve it at a mediation, for instance? If you can resolve it at mediation, it'll be cheaper for you. But if it needs to go to hearing, well, you're going to have to prepare all the documents required for hearing. That's going to, eat into the size of the estate, and it's going to be costly. If there's only one applicant compared to if there's 5 applicants, that's going to affect the cost of it all. If there's a number of defendants and everybody needs to prepare, witness statements, it just all goes into the cost of it all.
Defendants, again, that's a criminal term, and the court is the court.
Yes, so defendants are really just the parties who are trying to uphold the will. So it's often the executors who are named in the will. They're often the people who are named as the defendants to the proceedings. But yes, they'll have their own costs, and generally a defendant's fees are paid from the estate, and they're entitled to be paid from what's in the estate. Whereas if you're acting for an applicant, their fees, well, it depends if you can get a lawyer who can act for you on a contingency basis, or if you can set up some sort of funding arrangement with your lawyer to pay the fees. But generally you would be paying your own lawyer's fees if you're the applicant. If you're successful at court, you would be entitled to get your ordinary costs paid from the estate. Now, ordinary costs are not usually all of your costs, but they are some of your costs. But if you're unsuccessful, then generally you would need to pay your own costs, and you may also be ordered to pay the other side's fees. So these are, big considerations to be making as to whether or not you should commence proceedings in order to contest somebody's will.
So if you are the defendant, as in the executor,
yes,
and the estate won't cover the estimated costs, what then?
Well, generally the estate would be paying your costs if you're the defendant. That would be an unusual situation to be in, where there's not enough in the estate to cover your costs. You could possibly ask for the plaintiff to pay an amount into court to cover the fees of the proceedings.
But that would mean there's nothing left, so there's nothing to fight over.
That's correct. So, generally as the defendant you would be entitled to have your fees paid out of the estate. It would be an unusual situation if the plaintiff was trying to contest the will and there was nothing in the estate. You would be writing to them and telling them that there's nothing in the estate, and trying to put them on notice that there's nothing in the estate, and you'll be seeking costs from them if they do contest the will, because yes, if there's nothing in the estate, well, I don't see what they'd be trying to make a claim on.
Yeah, I know. I've got a friend who's in that sort of situation, and the other side keeps fighting and fighting and fighting and fighting and fighting. Many years later, that's life.
Yes, it's an unusual one, Tony, I must say. But yes, you would be trying to reach some sort of an understanding with the other side, and trying to show them that there's nothing in the estate, so there's no point fighting about it, because otherwise you'd be paying fees out of your own pocket and they'd be doing the same thing, and really you're not going to get anywhere.
So we've covered a lot today. So let's do a quick wrap-up of the main points.
We've talked about the costs and how they might vary, but ultimately a defendant is entitled to get their costs paid out of the estate, and it's really an applicant's costs, it's dependent upon the outcome of the proceedings. If they are successful, then they're entitled to get their ordinary costs paid out of the estate.
Thanks for listening today. Don't forget to subscribe, and if you require any further information, please go to our website www.degroots.com.au and book a consultation. The contents of this podcast do not constitute legal advice and are of a general nature only. Listeners should make their own inquiries about their specific circumstances and seek legal advice.